In this talk, I will discuss about the Vice President of India as well as executive and legislative powers of the President of India. First, about the Vice President of India. The Vice President of India is elected by an electorate consisting of the elected and nominated members of both the houses of Parliament in accordance with the system of proportional representation by means of the single transferable vote and secret ballot. To be eligible for election to this office, one must be a citizen of India having completed the age of 35 and qualified for election to the Council of Estates. His term is 5 years, though it may continue beyond the term until a successor joins the office. She or he may resign by writing under his hand to the President and may also be removed from office by a resolution of the Council of Estates passed by a majority of all the then members of the Council and agreed to by the House of the People. The resolution having been moved after 14 days' notice. But this is not an impeachment as such. Now, functions of the Vice President of India. The Vice President is the ex officio chairman of the Council of Estates and holds no other office of profit. In the event of the occurrence of any vacancy in the office of President by reason of death, resignation, or removal, or otherwise, the Vice President acts as the President until a new President enters office upon election. If a President is unable to discharge his functions owing to absence, illness, or any other cause, the Vice President discharges his functions until she or he resumes office. During such acting or functioning, the Vice President will be entitled to all the powers, immunities, emoluments, and allowances of the President. Otherwise, she or he draws his salary as chairman of the Council of Estates. In the eventuality of the unavailability of both the President and the Vice President at office, as per an Act of Parliament, the Chief Justice of the Supreme Court, and in his absence, the next senior judge of that court discharges the functions of the President. In 1969, following President Zakir Hussein's death, the Vice President V.V. Giri demitted his office in order to contest the election to the presidency. Chief Justice Hidayatullah discharged the functions of the President until the election of Giri as president. In terms of Article 324, the responsibility to conduct election to the offices of president and the vice president is vested in the Election Commission of India. But all doubts and disputes arising out of or in connection with these elections shall be inquired into and decided by the Supreme Court of India. In case the election is declared invalid, none of the actions of the president or the vice president committed till the date of the court decision will be void. Please refer to Article 71. Now, executive powers of the President of India. The President of India is the chief executive of the Union. According to Article 53, the executive power of the Union is vested in the President and is exercised by her oblique him either directly or through subordinate officers in accordance with the Constitution. All executive actions of the Government of India shall be expressed to be taken in the name of the President. The President lays down rules on how her oblique his orders and other instruments will be authenticated. She or he also lays down rules for the more convenient transaction of government business and for the allocation of business among ministers. Please refer to Article 77. The supreme command of the armed forces is vested in her oblique him. The President has power to grant pardons, reprieves, respites, or remissions of punishment, or to suspend, remit, or commute the sentence of any person convicted of any offense. A. In all cases where the punishment or sentence is by a court martial. B. In all cases where the punishment or sentence is for an offense against any law relating to a matter falling under the executive jurisdiction of the Union. C. In all cases where a death sentence is awarded. These powers of pardon may also be conferred by law on state governors and other officers. All civil appointments in the Union government are made under the authority of the President as the chief executive, and all appointments in the armed forces are made under the authority of the President as the supreme commander of the armed forces. According to Article 310, every person who is a member of a defense service or a civil service of the Union or of an All India service or holds any post connected with the defense or any post under the Union holds office during the pleasure of the President. The President has the power to appoint some constitutional officials for whose removal there are special constitutional procedures. The constitutional officials are the ministers of the Union, including the Prime Minister. Refer to Article 74. State governors. Refer to Article 155. Judges of the Supreme Court of India and the State High Courts. Refer to Article 124, Clause 2. The Attorney General of India. Refer to Article 76. The Comptroller and Auditor General of India. Refer to Article 148. Members of the Election Commission. Refer to Article 324. And the members of the Union Public Service Commission. Refer to Article 316, Clause 1. The ministers of the Union, including the Prime Minister, the Attorney General of India, and the governors of states, hold office during the pleasure of the President. But for the removal of the other constitutional office holders, a detailed procedure has been laid down. Each House of Parliament has to make an address by a majority of its total membership of, and a majority of not less than 2/3 of the members present and voting in each house in the same session, asking for their removal on the ground of proven misbehavior or incapacity. This procedure informally is called impeachment, but there are some fine technical differences. There is the requirement of 14 days notice in the impeachment of a president, which is absent in the other cases. The House to which the charge against a president is preferred has to conduct an inquiry into the charge, and the president is allowed a hearing as well as legal representation. In the other cases, these steps are not required. It is necessary to note that the Indian Constitution formally recognizes the President as the chief executive, not as the head of the state. Although all the powers traditionally belonging to a head of the state, including that of appointment of diplomatic representatives of India, are vested in her/him. In fact, the concept of the head of the state is a vestige of monarchy. It does not exist even in the Constitution of the USA, except for ceremonial purposes. Now, legislative powers of the President of India. The President is a part of Parliament, but not a member of any of its houses. Her/his legislative powers begin with the power to finally decide on a question of disqualification of a member of Parliament. Refer to Article 103. According to Clause 2 of the same article, however, before giving the decision, President shall take the opinion of the Election Commission and shall act according to such opinion. Routine legislative powers of the President encompass a set of activities beginning with the summoning of the Houses of Parliament and proroguing them. They may be said to be ending with the dissolution of the House of the People. C oblique he has a right to address either House of Parliament or both the houses assembled together and require the attendance of the members for the purpose. C oblique he can send messages to any House of Parliament on a pending bill or any other matter. At the commencement of the first session after each general election to the House of the People, and at the commencement of the first session of each year, C oblique he addresses the joint sessions of the two houses to inform Parliament of the causes of its summons. Whenever there is a disagreement between the two houses, C oblique he causes a joint sitting of the two houses but does not address it. Refer to Article 108. No money bill may be moved in the House of the People without the prior sanction of the President, because as the head of the executive, C oblique he alone knows what amount of money to be demanded of the legislature, and C oblique he alone may decide how to collect it. According to Article 111, the President's assent is necessary for all bills passed by the two houses of the Union legislature to become acts. However, if the President withholds her oblique his assent from a non-money bill, C oblique he may return the bill as soon as possible to the legislature with suggestions for amendment, if any, for reconsideration. The houses must do it. If they send the bill again with or without the amendments suggested, President has to give her oblique his assent. However, there is no limit to the time between receiving a bill and returning it to the legislature. Effectively, this may kill a bill. There is no definite dictate of the Constitution that President cannot absolutely withhold her oblique his assent to a money bill or a non-money bill. But there are some practical limitations to the use of such an absolute veto. In the first place, President has consented to the introduction of all money bills. Further, no money bill can be amended from the floor of the House. A money bill on rare occasions may be amended if the executive accepts such amendment. Even a private member's bill may be passed only with the executive's support. Therefore, President has no alternative to signing a bill on the advice of the Council of Ministers. There is only one possibility of a bill passed by the legislature being vetoed. If the Council of Ministers changes during the pendency of the bill with the President, the new Council may advise the President to veto a bill. When Parliament is not in session, if President considers it necessary, C oblique he may promulgate ordinances that will have the force of parliamentary acts. Ordinances are temporary laws made by the executive. In the past, members of parliament have protested against issuance of ordinances shortly before the commencement of sessions of parliament. They are alleged to have been used to preempt legislative deliberations by delivering fait accompli. This power does not belong to the British Crown, but it was granted to the governors and Governor General in colonial India. In the bank nationalization case, Cooper versus the Union of India, in 1970, the Supreme Court noted the possibility of prorogation of the House with a view to passing an ordinance after that. The silver lining is that such ordinances will be placed in both the Houses of Parliament and will lapse after 6 weeks or earlier if they are disapproved of. They may be withdrawn before that period too. If the two houses are summoned on different dates, the 6 weeks will be counted from the latter of these dates. The other silver lining is that no appropriation of money from the consolidated fund of the Union or a estate is possible by ordinances. Ordinances are in any case best resorted to at minimum frequency. The President also has certain emergency powers about which we will discuss separately in subsequent talk. In brief, this is about the Vice President of India as well as executive and legislative powers of the President of India. In my next talk, I will discuss about the Union Council of Ministers, the ministerial system, and the Attorney General of India. Thanks for patient listening.